Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. I have been batching a bunch of episodes for you all, so hopefully you'll enjoy that. Welcome to Grace and Gavel, where truth meets compassion. Today we're talking about even if you're innocent, it's too late. The power and failure of a post-conviction claim of innocence. Welcome to Grace and Gavel, where we explore how the law actually works, not just how we wish it worked. Today's episode asks a stark question. What happens when the system says, even if you're innocent, it's too late? Because shocking as it sounds, proving guilt was a mistake isn't always enough to undo a conviction. And in the U.S. criminal justice system, that truth sits at the collision point of justice, morality, and institutional rigidity. And this isn't academic. It has shaped the lives of real people who spent years, decades, even a lifetime behind bars for crimes they didn't commit. Let's talk about legal innocence versus factual innocence, and the distinction matters. First, we need to understand two very different concepts. Legal innocence. You weren't free to leave because the conviction stands, even if the legal process accepted all the government's evidence at trial. Factual innocence. You didn't commit the crime. Full stop. No reasonable person would believe you did based on the actual facts. Here's the twist. Proving one does not automatically guarantee relief under U.S. law. You can be factually innocent but remain legally convicted. Why new evidence alone doesn't reopen cases. You might think that newly discovered evidence like DNA or a witness recantation should automatically reopen a case. But under current law, that new evidence only becomes relevant if it meets extremely high bars. It must not have been discoverable earlier with due diligence. Courts will reject evidence as not new if it could have been found before trial. It must be reliable and credible. Jurors must be shown that the new evidence would likely prevent any reasonable juror from convicting, which again is a huge bar. Because if you have one, then you convinced any juror, right? One juror. But even then, and this is the real kicker, new evidence doesn't automatically overturn a conviction. It simply opens the door to review the underlying constitutional claims. The actual innocence gateway, the highest hurdle. The U.S. Supreme Court has said that someone can sometimes bypass procedural bars like missing deadlines or failing to raise issues earlier only if they can show actual innocence. This is known as the actual innocence gateway. The key case here is Schlupp versus Dello from 1995. Where the court held that a condemned man could avoid procedural barriers if credible new evidence made it more likely than not, which is the civil standard, that no reasonable juror could convict him. That sounds hopeful, right? Until you dig into how rare it is for the courts to find this standard satisfied, because that is almost an impossible burden, seems like, right? A high bar. Why almost no one passes through the innocence gateway? It's not enough to show you're innocent. Federal courts have repeatedly held that actual innocence isn't a standalone claim. You must link that innocence to an underlying constitutional violation. Habeas corpus, for instance, the legal mechanism for post-conviction relief, is narrowly limited to statute and court rulings. Procedural traps abound. Missed deadlines, exhaustion of state remedies, and restrictive standards mean that many meritorious innocence claims never see a merits hearing. That's unfortunate. Even when new evidence is actually game-changing, courts rigidly define what counts as new. Some courts require that it couldn't reasonably have been found earlier, making the bar even higher. How habeas corpus theoretically works and why it fails in practice. Let's briefly explain the legal tool most wrongfully convicted people use to challenge their conviction, the writ of habeas corpus. In theory, habeas corpus allows a federal court to review whether someone is being held in violation of Constitution or federal law. But in practice, federal courts defer heavily to state court findings, which is a lot of times they affirm the court's findings, the state court, because they are the original triers of fact. The person who is in the appeals court is reading the record, but they're not able to judge whether or not the person testifying is telling the truth or not telling the truth, or their mannerisms or anything like that, because they are not there. The trial court was there. So a lot of times they defer to them because they were the original trier of fact and they actually saw the witnesses and deferred to them when they wrote their ruling or their judgment, whatever you want to call it. But in practice, Congress added procedural limits, especially under the 1996 Anti-Terrorism and Effective Death Penalty Act, that restricts successive petitions. Even if you prove innocence, the court may still deny relief if there's no underlying constitutional error tied to it. And in 2023, the Supreme Court closed another avenue. In Jones v. Hendricks, federal prisoners can no longer raise a legal innocence claim if they already challenged their conviction once, even if that claim wasn't available earlier. Put simply, even actual innocence isn't always enough to unlock the door. Real people and real consequences. Let's bring this home with lived examples. Herrera versus Collins in 1992. Lionel Herrera was convicted of murder in Texas and later presented affidavits suggesting his brother committed the crime instead. The U.S. Supreme Court held that a claim of actual innocence alone did not entitle him to habeas relief. 4 months later, he was executed, proclaiming his innocence. This case perfectly illustrates the cruelty of the current system. Innocence without constitutional error doesn't guarantee relief, and that is really sad. Letheriel Boyd from Chicago, Illinois. Boyd was convicted of murder and spent 23 years in prison. Investigative reporting and new evidence eventually led to his exoneration, but his appeals had failed multiple times before new scrutiny by prosecutors, conviction integrity units. His case shows both the power of perseverance and the institutional hurdles that can keep innocent people behind bars for decades. DNA exonerations via Innocence projects. Across the U.S., organizations like Georgia's Innocence Project have helped free numerous convicted people through post-conviction DNA evidence. But for every success, there are many more stories where legal barriers like timing, procedural defaults, and evidentiary standards blocked justice. Why this episode matters. Today, we've looked at a chilling truth. The law seeks finality. Crime convictions must end somewhere, and the system values closure, even when it sacrifices accuracy. Innocence isn't a standalone legal claim. Factual innocence must be married to a constitutional violation to qualify for relief. The actual innocence gateway exists, but almost no one gets through it. The threshold is unforgiving and rare to satisfy. Habeas corpus is theoretically powerful, but practically fragile. Institutional rigidities and procedural barriers swallow many deserving claims. Let's do an outro here. These are not abstract legal doctrines. They are the threads that decide whether a person walks free or stays locked up. There's power in the law, and there is failure in how we apply it. Because we're human, right? Understanding both is key to uncovering the full truth about justice. Thanks for listening to Grace and Gavel, where truth meets compassion. If this episode struck a chord, share it and join us next time as we continue to unpack the gap between legal truth and real justice. Additionally, let me give you some real life examples to help you conceptualize what's going on. Let's talk about success stories where innocence was recognized, because it's not all doom and gloom, thank goodness. These are the cases where individuals eventually had their convictions overturned based on new evidence and or successful legal strategy. Brian Bowles and Charles Collins were in New York in 1994 murder. In 2025, a Manhattan judge vacated, which means he overturned, the convictions of Brian Bowles and Charles Collins for the 1994 murder of an 85-year-old man after DNA testing of fingernail evidence excluded both men and pointed to another unknown source. Prosecutors and defense counsel jointly agreed that the convictions could not stand based on the modern forensic results and flaws in the original case, including coerced confessions and undisclosed evidence that undermined police testimony. Grounds for relief: modern DNA evidence excluded them. Prosecutorial review acknowledged systemic flaws, and the judge vacated convictions and dismissed charges. This case powerfully shows how new scientific evidence, when combined with prosecutorial willingness to revisit a case, can finally clear the innocent, even decades later. And honestly, why wouldn't a prosecutor want to actually help with the case when someone has been wrongfully convicted? DNA-based exonerations: Thomas McGowan and Stephen Phillips from Texas. In multiple Texas cases, defendants convicted decades earlier won exonerations through post-conviction DNA testing. Thomas McGowan was exonerated after DNA testing proved another man committed the crime, overturning a conviction based largely on eyewitness misidentification. Eyewitness identification is seriously flawed. People are often under a lot of stress. Not that they intentionally accuse someone, but mistakes happen. Stephen Phillips sought DNA testing for decades. When the lab finally tested evidence in 2006, results proved he could not have committed the sexual assaults. And in 2008, the Texas Court of Criminal Appeals officially exonerated him. Grounds for relief: post-conviction DNA testing unavailable or denied at trial, scientific exclusion of the defendants as perpetrators. Courts had authority under state post-conviction testing statutes. These show how persistent legal pressure and advances in forensic science can overcome procedural obstacles and unlock relief. Glendale Woodall. Woodall was convicted in 1987 for sexual assaults after flawed forensic serology testimony. Decades later, courts found that the analyst involved, Fred Zane, had framed hundreds of people with false evidence. The West Virginia Supreme Court ordered new trials and ultimately cleared Woodall's name. Grounds for relief: exposure of wrongful forensic testimony used at trial. And honestly, I think that person should be convicted because the guy's been in there since 1987. And it's crazy. State court ordered new proceedings and conviction ruled invalid based on faulty evidence. This illustrates how institutional review, when it finally happens, can correct even long-standing errors. Unfortunately, Mr. Woodall cannot get all those years back that he spent in prison for something he didn't do. Beatrice 6, in Nebraska, 1989. 6 people wrongfully convicted of rape and murder were exonerated in 2009 after DNA evidence linked the crime to another suspect and debunked coerced confessions and misleading psychological techniques used by investigators. Grounds for relief: DNA evidence excluded defendants. Exposure of coerced confessions and investigative misconduct. There's no reason why law enforcement officers should do the coercion. There's no reason for that. I mean, that is just ridiculous. This case powerfully demonstrates how forensic results combined with scrutiny of investigative techniques can finally undo wrongful convictions. Cases where innocence claims failed. These finalists illustrate how the law can still deny relief even when there's credible evidence of innocence, often because the claim wasn't tied to a constitutional violation or couldn't overcome procedural barriers. Herrera v. Collins, 1993, U.S. Supreme Court. Lionel Torres Herrera was convicted of killing 2 police officers in Texas and later filed a second habeas corpus petition asserting new evidence of innocence, including affidavits suggesting his brother committed the murders. The Supreme Court held that proof of actual innocence alone does not entitle a defendant to relief, unless tied to a constitutional violation. Why relief was denied: no accompanying federal constitutional violation, example, ineffective counsel, due process violation. Supreme Court said innocence by itself isn't a basis for habeas relief. Critically, Herrera's case underscores the brutal reality that factual innocence doesn't automatically translate to legal relief in federal habeas corpus proceedings. Federal habeas corpus procedural barriers, white paper data. Empirical studies of federal habeas corpus show that less than 0.4% of petitions by state prisoners result in any relief, even though organizations have identified hundreds of wrongful convictions via DNA testing. Why many fail? Procedural default. Claims barred if not raised earlier. AEDPA limits strict standards on new evidence and timing. Courts demand proof that constitutional error occurred caused the conviction, not just proof of innocence. These procedural hurdles mean many innocent prisoners never even make it to a merits hearing, which is really sad. Juan Rivera from Illinois. Juan Rivera was wrongfully convicted 3 times in the same murder case, despite evidence excluding him. Even after the DNA excluded him, prosecutors repeatedly retried him until an appellate court finally overturned the conviction due to insufficient evidence, not because of a straightforward innocence claim. Why this matters. Rivera was ultimately released. His release hinged on appellate sufficiency standards rather than a clean innocence review. The prosecution fought retrial despite DNA exclusion. This illustrates how even overwhelming scientific evidence can be fought by prosecutors, and relief may come only through appellate technicalities. I don't want to say technicalities because I don't really like that word. Probably appellate cases, not technicalities, rather than clear acknowledgement of innocence. What these examples teach us: success often depends on scientific advances like DNA and legal persistence. Procedural rules and habeas limitations pose enormous barriers even to innocent defendants. Actual innocence isn't enough. The law often demands you tie it to a constitutional error, and cases like Herrera show that the highest courts can reinforce limits on innocence claims. Also, I want to say that there are many defendants who do not have access to these things because they are lower socioeconomic status. There are a lot of people who are on death row because they were too poor to get an attorney, and attorneys are really important in cases like this, especially where they're trying to do appeals and complicated issues. I myself don't do appeals, but there's a lot that goes on with those. And when somebody is facing death and things like that, which happens to disproportionately people of lower socioeconomic status who don't have the means to hire an attorney, and oftentimes a lot of the public defenders are kind of overworked, right? Not making excuses for them. And then also you have the highly technical landscape of an appeal. And so that makes things ripe for a lot of wrongful convictions. And it's truly sad that there are so many barriers in place for people to actually get out of somewhere where they don't belong. And my heart aches for all of them. So thank you for tuning in, and I hope you have a great rest of your day. And like I said, if there are topics that you are interested in, feel free to drop them in the community and I will check them out. Know that I engage with the community and know that I appreciate every single one of you for tuning in. It means a lot. Hope you have a great rest of your day. Bye.